Good morning, everyone. All right, let me turn up this. Good morning, everyone. How's everyone doing today? Happy Hump Day. Good morning, PD on Instagram. Hi, Vector on Instagram. Hi, YouTube. Hi, Facebook. Um, Comment in the box. Let me know where you're tuning in from and where you're joining us from. If this is your first time, definitely comment in the box. Let's know where you're joining us from so I can give you a shout out. Phenomenally good morning. Um, so today is really, a frequently asked question day. So you guys have the floor. I don't have any particular topics. Just chit chatting. If you have questions, definitely ask them today. If I can answer them, I will. PDE from NYC and Zarnila from NYC. Good morning. Good morning. That's my hometown. Good morning, Damba on YouTube. Good morning, Sonia. Thank you. From Baltimore. Dwynette. Good morning. Good morning, Brandon. Good morning, Ebo from North Carolina. Good morning, Jemima from Illinois. Good morning, everyone. Um, so today, let me introduce myself first. So for those of you who don't know me, or for those of you tuning in for the first time, my name is Aisha Chidole. I'm an immigration attorney and I represent clients all over the United States with their family immigration matter. Regardless of what state you're in, I'll be happy to assist you. My number here is 407-995-6567, and you can send us a WhatsApp message, 404-333-8751. Um, so, and before I get into your questions, feel free to ask your questions. I wanted to remind you guys about my 10 days of giving giveaway. It starts tonight. So the first winner will be announced tonight, and we're going to announce a winner every night. And then on the 20th, a grand prize winner of $500. So somebody will win $100 every night. People have asked me, and I've seen some people also filling this out. If you do not live in the United States, you'll be disqualified. If you don't qualify to enter, you have to live in the United States to do it, and you have to have an immigrant story to qualify. So just follow the instructions to enter. Okay. All right. So some of you jumped right in. Let's tackle some questions. So somebody on Facebook asked, I have an appeal case 290B, and I got an update that my name was updated. What does that mean? It means nothing. It just means that your name, maybe your spelling was wrong, and they just fixed it. Sometimes you might have like a spelling that's off on like your actual filing, or like on your appeals, and when they catch that, they make an update, and stuff like that, but it doesn't mean anything at all. Good morning, Justina from Los Angeles. Good morning, Christy from Maryland. Good morning, Dev Chin. Zanila said, I applied for VAWA in July of 2019. I received updates stating correspondence received, and USCIS is reviewing it. What does it mean? It means, did you send them something? If you sent them something, they're basically saying that they received that, and they're reviewing whatever it is that you sent them. That's essentially what it means. Hi, Miss Cranberry. 77 is asking about a giveaway. Yes, I do have a giveaway. And you can look at that once you get off my live. I have a few posts about the giveaway. So you can definitely enter if you qualify. Okay, so while you guys are typing your questions, let me talk about some few frequently asked questions that I get. And if you have any, you can ask me. If not, I will log off, if you have no questions. One of the questions that we get a lot is how soon after marriage to a U.S. citizen can we submit a petition? So the answer is, I'm actually on the live right now. Somebody's knocking at my door. So how soon after your marriage can you file a marriage petition? So the answer is as soon as you want. Well, let me preface by saying that First of all, you should not be filing a marriage petition or any petition for that matter if you came here on a B1, B2, if you came and it's been less than 90 days. Because if you do that, there's a presumption of misrepresentation. Because, generally when you go through Customs and Border, like, oh, what are you here for? How long are you here? So, if you didn't tell them that you were planning to get married, you don't want an issue with that. But otherwise, there is no timeline when you can submit a petition when you're married. Obviously, the only thing is that if you do submit a petition right after you get married, you're not going to have as much bona fides as somebody who has been married for a little bit. And if you are one of those who fall in that category, you want to make sure that you start to accumulate organically things that show you have a bona fide marriage, so that by the time of the interview, you have stuff that you can take to the interview to show the bona fide nature of your marriage. If you got married in September and you submitted your petition end of September or October, nobody's expecting you to have a list of things. So what you can do is, if you have things prior to the marriage, you can send those things. And then by the time you get to the interview, you can send, these days the interviews take about a year from when you submit your petition. So then you can send those things that you've, gotten together over the year, or if they request additional evidence to prove bona fides, then you can also send it at that time. Usually the RFE will come a couple months later. So just try to continue to accumulate things, so you're not limited, basically. Somebody said, hello, I filed for VAWA and I haven't received a receipt from them. It's now 2 months. What should I do next? Well, it's usually difficult to track if you've not received a receipt and you didn't pay a filing fee. So, I know you said you filed for VAWA, but the question is, did you submit it with an adjustment of status? If you submitted it with an adjustment of status, did you pay with a check? If you paid with a check, you can always track the check to see, has a check been cashed? I personally prefer to send checks because it helps me to track, so that even if a receipt is delayed, I know whether or not, if it's been cashed, and I know it's coming. It's you as a person on your own will never be able to follow up for a VAWA case. You need a lawyer to follow up with you, because VAWA cases are confidential cases, so they will not speak to you, or they will not give you any information if it's a VAWA case. So you need to contact a lawyer. If you use one, contact your lawyer. If you didn't use one, you can certainly schedule a call with me, and we can see what exactly you filed and why you've not received your receipt. Okay. And it could be that you also sent it to the wrong address, because last like 3 months ago they changed your address, so it's possible that you sent it to the wrong address. So Christina says he does Christina, I don't understand. Is this in continuation to another question? So I don't understand your question. If you can give me the first context of the question so that I can understand what it is you're saying. Sonia says, I did recent fingerprints for my I-765 form with a 290B case as well. What do you think? Guys, I am not understanding your question. 765 is your work permit. Your 290B is an appeal of a denial. So what is your 765 for? Was your case denied? Obviously, if I'm assuming your case was denied, which is why you're filing an appeal, correct? So if your case was denied, you're not going to get a work permit if there's nothing that's pending on. And then my content says, how long does it take to get EAD TPS? Honestly, I don't know the answer. I don't know the answer right now, because, if you are like from Haiti, I'm assuming that you probably are, or Venezuela. Right now, Haitian TPS just started a few months ago. So we are all waiting for it. So, my assumption is that the timeline is going to be the same or similar to a normal marriage-based case. But then again, it's a different category, so I don't know. It's something that I would have to check the processing time, but it's, it's really hard to say, just because the first batch from this new influx of applications have not been released. So, I can't really give you an estimate, but you can check the USCIS processing time with wherever your processing center is, and maybe you have a bit more clarity. Okay. If someone missed their visa appointment, Barbados, how can they schedule for another appointment? How long will it take? Oh my goodness, that's awful. You might want to contact a U.S. embassy. I don't know how Barbados embassy works and how long it will take, but plan for a couple months. Plan for a couple months because just the basic biometrics, if you miss your basic biometrics right now, it takes a couple months to be rescheduled, and then you're outside the country. So it's probably going to take a couple months. Can someone renew their work permit authorization while the interview is still pending? Absolutely. As long as your I-485 is pending, you can still renew your work permit. Afro-American Chop. Hi, Thelma. How are you? Funky says, I have a notice of intent to deny. What should I do? You need to respond to the notice of intent to deny. If not, they will deny you. So it just depends on what your notice of intent to deny is saying. You can certainly call my office so that I can review it and see if it's a case that I would take. And I can guide you in how we would respond to it. My number is 407-995-65. No, 407-995-6567. And it's also in my profile, so you can check there. Ms. Cranberry says, how do you secure yourself when married to an undocumented individual? What do you mean by how do you secure yourself? Like, I don't really understand that question. Funky says, they judged me for my last application in immigration. Why? I see. So Funky is the one who said that she received a notice of intent to deny, and you're saying that the contents of your notice of intent to deny is basically judging you from your last application in immigration. I don't know the particularities of your case, but it's a segue to a topic that we see coming on my desk a lot, where people get married and USCIS says that they have a sham marriage or a marriage fraud, and then they go marry somebody else and they're like, okay, this marriage is wonderful, we have kids, I will definitely get approved. No, that is not how it works. So if you were judged a marriage sham from the previous case, they will still focus on that, whether or not you have a legitimate marriage, until you can prove basically a marriage sham. If you have a judgment of marriage sham that you're not able to overturn, you will never be able to adjust your status and get your green card. So you need to find whatever it is that, I don't know your personal situation, don't know your personal case, but for any of you who are in that situation, you need to prove that your previous marriage was not a sham in order to get through to your second marriage. Hi, Wilson. Good morning. Hi, Marie. Fabito says, what do you do? They send your card to the wrong address. You have to request a new one if they sent it to the wrong address. Sometimes you're going to have to pay for that if you so like if they can show proof of delivery and the wrong address was your fault and not USCIS fault, you're going to have to pay for a new card, and it takes months, like almost like 8 to 10 months for you to get a new one, just so that you know. So if there's a way that the address it was sent to and you're able to go there and get it, then you should probably go get it. Okay. So Christina says, I mean, my brother moved from one state to another and he didn't notify the USCIS since he's using a lawyer's address. Is that okay? No, that's not okay. Whether or not you're using your lawyer's address, it is important that you notify your attorney or USCIS that, well, if you have a lawyer, notify your lawyer so they can help you with that you've changed your address. The reason why is because, one, you don't want a situation where they send you biometrics notice and you cannot get to the biometrics location because it's across the country based on your old address. Same applies to interviews, because sometimes they can give you notice, but sometimes, especially now during the holiday season when mails begin to get delayed, you might literally have like 5 days notice, to get to your biometrics, to get to your interview and stuff like that. So you always want to notify them once your address changes, okay? Especially when you move to another state. Okay. Brendan says, good morning, Aisha. You skipped my question up there on prima facie. So just so you know, I have so many questions. I might not be able to get to all of them. I might not see them, and I actually don't see your question. So you can post it again. Um, okay. Let's see what else we have here on Instagram. How can an employer file for an employee if that person overstayed their visiting visa? They can't. You can't overstay if you want an employer to file for you, because obviously if an employer is filing for you, it means you don't have a qualifying relative, which is needed to do a waiver and go back to your home country and finish. Um, And Zanila says, another question. I sent through my lawyer EAD renewal in December of 2020. I got no receipt or card. I sent it again in September. Still no receipt. In your opinion, what is happening? Zanila, you should be asking this to your lawyer. If you have a lawyer, you should be asking this question to your lawyer. Your lawyer should be able to answer you. You should have receipt notices, though. Can somebody still marry a U.S. citizen if the person does not have status in the U.S.? Absolutely. You can marry a U.S. citizen if you don't have status. As a matter of fact, if you do marry a U.S. citizen while you're here in the United States and you came in here like on a visiting visa, F1 visa, you can adjust your status here without leaving the country. Now, if you are here on like a crewman visa because you were supposed to go on a cruise and you didn't go on a cruise, you can adjust your status through a normal marriage-based case. Okay. Okay. Um, let me see. Okay, so Brendan, I see your question now. Can a prima facie be used for employment while waiting for EAD renewal approval? The 180 days extension expired as well. Unfortunately, you cannot use it for employment. So, Seaview, the answer is yes. Your brother, even though he's an overstay in the US, well, the answer is yes, depending on your brother's entry, how he entered into the United States. If he entered into the United States with like a visiting visa, like a B1, B2 visa, and he married a US citizen, then yeah, he can still qualify to adjust his status. If he crossed the border, no, he will have to finish his process outside of the United States, or if he entered with a crewman visa, which I just talked about. Um, One Honey says, do you have any information about the new immigration bill and what to look for? At this time, no. I mean, it's like, every time I talk about it, then they go back to Senate and they change it and they go back and forth. So until something is actually really put into law, like, at this point, it's like a moot point talking about it because I don't want to raise you guys hope and give you guys false dreams that don't actually go to don't go into a bill. So right now, it's really just a waiting game. Okay. Can you file for your child if you're on a 10-year green card? Absolutely. But depending on where your child is, you're going to either have to do an adjustment of status or consular process. You can do an adjustment of status if your child is currently in status in the United States. Otherwise, you have to do consular processing. Um, can a green card holder remarry after they've been divorced by a U.S. citizen? Yeah, they can remarry. Let's see what else do we have here. Okay, guys, I have about 5 more minutes. Let me see what else I haven't answered here. This question says, good morning. If someone misses their date of interview and you get mail that says it was denied, what can you do? You can't do anything. You have to file again before you put in removal proceedings. Okay? Oluwaseun says, can my friend travel to Canada with her authorization with advance parole? Without knowing your friend's immigration status, I cannot give her advice. But generally, if you're not in removal proceedings and you currently have a pending case and you have advance parole, you should be able to travel and come back. Your connected says, what do I do if I suspect VAWA fraud? Contact USCIS. Can I change my visa interview location for F11? What is F11? I don't understand the question. Um, let's see what else we have here. Sorry, guys, I'm just trying to read these questions. If you're denied, somebody asked if you're denied after an interview, what can you do? What you can do is first have an attorney assess why you were denied. Sometimes it is actually better to refile your application than to file an appeal, but the situation depends on what is causing your denial, what the chances of, or the length of time it will take for an appeal decision, to evaluate what your best options are. So, definitely give that to an attorney to review so they can review the reason for your denial, and then they can give you proper legal advice whether it's better to file an appeal or whether it's better to just file a new petition. Um, and then this person says, what are the chances of winning an immigration VAWA appeal cases? That's not a question that is realistic for anybody to answer without knowing your case and what you were denied for and what you responded in your denial. So that is a statement that nobody can give you an answer to unless they know what you were denied for and what you submitted in your appeal. But are you asking, do people win appeals? Yes, we've won appeals for many people, many of our audience here. But again, that is specific to their own case, why they were denied, why we filed an appeal, and stuff like that. So you said you're denied for lack of evidence. That's still not enough. That's still not enough for me to tell you. So Lily the Great says, can a mom file for her unmarried daughter who is over 21 years old on an F1 visa? So is the mom a U.S. citizen? If the mom is a U.S. citizen and she's currently in an F1 visa, she can file for her. But she cannot file adjustment of status because remember, because she's over 21, she is in the F1 category, which is the family preference category. So, it's still like a 6 to 7 year wait time. So if she's on an F1 visa, let's say she just started college or something like that, strategically, one of the things that she can do is stay in college, do her 4-year college, pick a STEM major, and maybe go to a master's program or a post-baccalaureate program, or try to get into OPT. OPT is a 3-year option that you have when OPT, for those of you who don't know, is occupational training. I don't really talk about employment or educational immigration on my platform because I'm a family immigration lawyer, but I'll just quickly explain that to you. And then once, so maybe that will help her to buy some time so that by the time her visa becomes available, she's still in status and then she can adjust her status. But if she's out of status by the time, her mom's I-130 gets approved, and she, she would have to consular process after getting a hardship waiver approved. If the mother is a green card holder, she can still file for her. She will just be in a different class, but she cannot, and that class takes a little bit. Actually, no. Right now, green card holders filing for their children that are over 21, it's 1 year shorter than U.S. citizens, but she will still have to do the same thing that I just mentioned, and she cannot marry if the mom is a green card holder. If not, she won't be eligible. Can a B1 visa change status to an F1 visa? Absolutely. Can one file for citizenship while going through a divorce? I've been a green card holder for 4 years. So if your green card is not on the basis of marriage, you need to be a green card holder for 5 years before you file for citizenship. If it is on the basis of marriage, because you're going through a divorce, you're no longer eligible for the 3-year requirement. So you have to wait 1 more year. Well, technically 4 years and 9 months. After that, you can submit your application. Okay, basically 90 days before the 5-year anniversary. Grand Crystal on Instagram says, can your abuser, and this is the last question I'm going to take, Can your abuser stop your VAWA case? No, your abuser cannot stop your VAWA case. USCIS is not allowed to disclose that you are a VAWA applicant or that you have a case pending. If you're contacted or if anything is sent to them, this is for your safety and your security, and especially because they know this is what abusers try to do. Okay, guys, if I didn't answer your question, I see some people here taking it personal that I'm ignoring their questions. I am not ignoring your questions, guys. First of all, nobody's entitled to me answering the questions. This is a free service that I give you, so you're not entitled to me answering your questions. But I cannot see all questions because I get a lot of questions, so I just try to go through as many as I can. On that note, if you want to enter the giveaway, definitely enter the giveaway. I will be drawing out tonight at 8 p.m. I will be announcing the first winner. So tune in on Instagram and Facebook only to find out who's winning the first $100. Again, follow the instructions to enter. Okay? All right, guys. I hope you have a wonderful day. Bye.